Hi everyone, we are going to represent the Judiciary of Armenia. History. On November 8, 96, new judicial system was adopted, formed and started to function. The courts are First Instance Courts of General Jurisdiction, Administrative Court, Court of Appeal, Court of Cassation, and Council of Justice. Courts of First Instance in RA. All criminal and civil cases, as well as cases on the specification of the lists of electors, are under the jurisdiction of the Court of General Jurisdiction of that certain community or district. In the Republic of Armenia, there are 17 courts in general, 7 of which are located in different communities of Yerevan, and the other 10 courts in several districts of Armenia. The court solves the issues related to choosing the detention as a precautionary measure, permitting the search in the apartment, as well as it examines other cases on merits stipulated by the criminal procedure legislation. The court consists of one chairman. Positions of a secretary and an assistant are each prescribed to every judge of the court. The court has a staff, which is the separate subdivision of Judicial Department RA, and serves to ensure the regular activities of the court. The legal status and functions of the staff of each separate court are stated in RA laws by the separate special legislation written for each district and by the decisions of the founder and other legal acts. Authorities of the chairman. Ensures the regular activities of the court, follows the provision of the work discipline of the judges, follows the process of meeting the deadlines of investigating cases by the judges, and in missing the deadlines of investigating cases is representing his judgment to the Ethics Commission of the Council of Courts chairman. In discovering a violation of the requirements of the discipline legislation, when necessary, respectively sends a report concerning that issue to the Ethics Commission of the Council of Courts chairman. Provides holidays to the judges as prescribed by law. In case of a holiday or some other temporary absence of the judge, if necessary, redistributes the cases under the latter's responsibility. Access to the court. Article 8 of the Universal Declaration on Human Rights confirms that each individual, in case of violation of basic rights given to him or her by the Constitution or by law, has a right to effectively recover those rights through competent national courts. Based on the principle of separation of powers from the bodies of state power, the mission of protecting the interests of an individual and the state is put on the court. The courts are called to solve the controversies which arise between an individual and other members of society, as well as with state bodies, and to ensure the rights and fundamental freedoms of an individual.
Administrative Court of the Republic of Armenia. The Administrative Court has been formed and functioned from 1st January 2008. The court examines disputes on merits emanating from public legal relationships, that is, disputes in which on the one side is a body gifted by administrative powers, a subject of private law on the other side. All the cases arising from public legal relationships fall under the jurisdiction of the court, including the dispute is connected with starting or performing public or alternative service. The dispute is between administrative bodies which are not subject to solving by the order of precedence. The cases with disputes pertaining to the suspension or termination of the activities of unions, including trade unions, acting or aiming to act in the sphere of public law. The cases on issuing payment order, which emanate from public legal relationships. Cases are being examined on merits in the court by a single judge for the first time, except the cases stipulated in the RA Administrative Procedure Code. The judicial acts deciding the case on merits of the court enter into legal force from the moment of their promulgation, and the interim acts enter into legal force after 1 month from the moment of their execution. Other term of entering into legal force of those acts can be stipulated by law. The court is formed of the chairman of the court and 19 judges. The chairman of the court is a judge and has the following authorities: provides the regular activity of the court, follows the judge's maintenance of working discipline, follows the judge's meeting of the case examination deadlines, submits his/her conclusion on the violation of case examination deadlines to the ethics committee of the council of court's chairman. Upon detecting a violation of the requirements of ethics code by judge, if necessary, submits a relevant notification about it to the ethics committee of the council of court's chairman. Provides leaves to judges by the order defined by law. The court has a staff which is separated subdivision of RA Judicial Department and serves to provide the regular activity of the court. The staff's legal status and order of activity are defined by RA laws, by chapter of the staff, by the founder's decisions, and by other legal acts. The court can be applied to by submitting the documents to the court office or delivering them by post. The order of applying to administrative courts is defined by Administrative Procedure Code of the Republic of Armenia. All disputes arising from public legal relationships are subject to be solved by the administrative court, except the disputes vested to the Constitutional Court.
The Court of Appeal. The Civil Court of Appeal reviews judicial acts deciding the case on merit of court of general jurisdiction within each jurisdiction, as well as the interim judicial acts in the exceptional cases stipulated by the law. The court is formed of the chairman of the court and 16 judges. The chairman of the court is a judge and has the following authorities: provide the regular activity of the court, follows the judge's maintenance of working discipline, follows the judge's meeting of the case examination deadlines, and submits his or her conclusion on the violation of case examination deadlines to the ethics committee of the council of court's chairman. Upon detecting a violation of the requirement of ethics code by a judge, if necessary, submits a relevant notification about it to the ethics committee of the council of court's chairman. Provide leave to judges by the order defined by law. In case of a judge's leave or other temporary absence, redistributes cases in his or her proceeding upon necessity. In case of the court chairman's leave or other temporary absence, appoints a replacement. Supervises the activity of the court staff, represents the court in the relationship with other bodies, exercises other powers vested to him by law. The Criminal Court. Cases of the Court of General Jurisdiction which have not come into legal force, and in the exceptional cases stipulated by the criminal procedure legislation, cases referring to the judicial acts which have come into legal force, are under the jurisdiction of the Criminal Court of Appeal. A judicial error, such a violation of material or procedural right which has influenced or could influence the outcome of the case, is a ground for lodging an appeal. The court reviews the judicial act within the frameworks of the ground and justification of the appeal. Complaints lodged against the judicial acts deciding the case on merits of the Court of General Jurisdiction are examined in the court collectively by a bench of 3 judges, and complaints lodged against judicial acts not deciding the case on merits by a single judge. The case examination is administered in the court by the rules stipulated by Republic of Armenia Criminal Procedure Code.
According to Article 92.2 of Republic Armenian Constitution, the highest judicial instance of the Republic of Armenia, except constitutional justice issues, is Republic Armenian Court of Cassation, which is called to provide the uniform application of law. The goal of the activity of the Court of Cassation is to provide the uniform application of law, the correct interpretation, and to contribute to the development of right. Basing on the complaint in a case stipulated by law and orders, the Court of Cassation reviews the judicial acts of the Court of Appeal and the Administrative Court. The act of the Court of Cassation enters into legal force from the moment of its promulgation. It is final and is not subject to be appealed. Currently, the Court of Cassation is formed of the chairman of the court, criminal chamber, civil and administrative chambers. The criminal chamber is formed of a chamber chairman and 5 judges. Civil and administrative chambers are formed of a chamber chairman and 9 judges. The Court of Cassation is headed by the chairman of the Court of Cassation, who is performing all the authorities vested to the chairman and judge of the chamber of the Court of Cassation by the law. The chairman of the Court of Cassation provides the regular activity of the Court of Cassation, summons and conducts the sittings of the Court of Cassation, sends the decisions of the Court of Cassation for publication in REA official reference book, provides leaves to judges of the Court of Cassation by the order defined by law, supervises the activity of the staff of the Court of Cassation. The Court of Cassation has a staff which is a separate subdivision of REA Judicial Department and is called to provide the regular activity of the court. The legal status and order of staff activity are defined by REA laws, by charter of the staff, by the founders' decisions, orders, and by other legal acts. Departments of legal expertise implement an important function in the system of the court. The latter implements an initial expertise of the judicial acts, decisions, and other documents of the court and provides its professional opinion about them.
The Council of Justice is an independent body which executes its authorities stipulated by the Constitution of the Republic of Armenia, by the order stipulated by the Judicial Court of the Republic of Armenia. According to RA Constitution, there are 9 judges in the composition of the Council of Justice, elected by the order defined by law, by the General Assembly of Judges of the Republic of Armenia by secret ballot, for a period of 5 years. The President of the Republic and the National Assembly each appoint 2 legal scholars. The Council of Justice forms and submits to the approval of the President of the Republic the list of candidates for judges and list of official promotion of judges, based on which are made the appointments. The Council of Justice gives a conclusion on the submitted candidates of judges, proposes candidates for chairman and judges of the Court of Cassation, its chambers, candidates for the chairman of the Courts of Appeal, first instance and specialized courts. By the inquiry of the President of the Republic, expresses opinion on the issue of pardon, imposes disciplinary liability on judges, presents a suggestion to the President of the Republic on terminating the authorities of a judge, an agreement for detaining a judge involving him/her as a defendant or imposing administrative responsibility on him/her by judicial order. While executing its authorities, the Council adopts decisions, gives conclusions. The Council of Justice carries out its activity through sessions. The session of Council is competent if more than half of the overall number of the members of the Council is participating in it. The Chairman of the Court of Cassation conducts the session of the Council of Justice without the right to vote. The Council of Justice forms a disciplinary committee consisting of 3 members of the Council for 1-year term. 2 judges and 1 legal scholar, members of the Council, are in the composition of the disciplinary committee. The composition of the disciplinary committee is formed by the order of rotation, taking as a basis the selection or appointment date of the Council member. The member of the Council selected or appointed earlier are in the composition of disciplinary committee. In case of coincidence of the dates of the Council members' selection or appointment, the composition of the disciplinary committee is formed by the alphabetical order of the surnames of the Council members. The disciplinary committee has a right to initiate disciplinary proceedings against a judge of the Court of First Instance and Appeal and against the chairman of the court, and apply to the Council of Justice with a relevant petition. Based on the application of the Ethics Committee of RA Council of Court Chairman, initiate a disciplinary proceeding against a judge of the Court of Cassation and Chamber Chairman, as well as against the Chairman of the Court of Cassation, and apply to the Court of Justice with a relevant petition.
Here is the link of our Wikipedia article. Thank you for your attention. Bye.